Hi guys, this is Rajiv Eskhana for immigration.com, the law offices of Rajiv Eskhana PC. Today is October 10th, Thursday. This is our community conference call, and as you would have heard in the announcement, does not create attorney-client relationship, etc., etc. The call is being recorded, be warned, and if you want to conceal your identity, feel free to do so because the call will be made publicly available. I will start first with the questions that have been posted, and then I will open to follow-up questions. I don't expect a lot of people to attend today, so we'll have plenty of time. Let me answer the questions first, then the follow-ups, and all the new questions. GK001 says, working while H-1B extension pending. Applied for my H-1 extension in May 2013. Approval is not in hand. Present H-1 expired, and when you say H-1 expired, I'm assuming it's the approval, the I-94. On September 25th, 6 years are over. How many days can I continue working? What are my options? If you actually have time coming to you, okay, like if you have 1 year extension because your labor cert was going on, or 3-year extension because your I-140 was approved, you can continue working for up to 240 days past September 25th, so almost 8 months. Okay, and if you are really in a nervous state, or you feel like you want an answer more quickly, you can always premium the pending case. Okay. Next one is Reina Reddy. Am I eligible for green card? Any special status to stay long time in USA? Living in Nashville, Tennessee, recently blessed with a baby girl. Daughter is a US citizen, but she's under special treatment, which is only available in the United States. That does not give you a green card. Okay. And the only thing I can think of is if a local congressman, federal congressman, not state, were to present a special petition for you, these are called private bills, private bill, which basically means your case is so sympathetic that a congressman steps forth and says, let's make a special law for Reena Reddy so she can get her green card. And cases like this, they can be approved under private bills. How do you begin that? Take some members of the local community and go meet your congressman and see what they can do. Okay? Private bill. Next question, TSK245. Graduated from Harguan, got an RFE during H-1B. One is curricular practical training. They want to see a cooperative agreement between employer and Harguan University. Well, you opted for CPT, but you canceled it. You did not work. So that should really cover it. All you need to do is get a letter from school showing that you never used the CPT. Instead, you got the credits through regular study. That should take care of this part. The master's cap, they want to know if your degree is from an accredited university. And that's something I can't help you with, because there the law is quite clear, and Harguan will not be able to help you there, and you will not be considered under master's cap if you don't have a degree from an appropriately accredited university. Okay. Mahesh, MK Vesh, green card filed by US citizen for wife. I am a US citizen, filed for green card, wife is on L1A. So they have filed I-13045 at the Chicago lockbox. Biometrics notice has been received. Is it okay to try to go for a walk-in biometrics? Yes, you can try. It depends upon the workload of the local office. If they have time, they will probably take you. Okay, they do it as a matter of courtesy. It's not a given. Don't think that's guaranteed, but they can do it. Is it safe? Yeah, I think it's okay. We did not file for EAD along with the application. Is it okay to file now? Absolutely. Is e-file okay? I don't recall if I-765 can be e-filed. If it can be, yes, it's perfectly fine. My wife's L1A will expire on November 23rd. If an extension is not filed, if the extension is timely filed, can she continue working on L1A? Absolutely. But if her employer does not file for an extension and EADs that does not come through, can she stay in the country? Absolutely. Because of the pending 485, she can stay and have no problem sitting at home. Once her EAD comes, she can work anywhere. She can start her own business. It's no problem. Okay. Spouses of U.S. citizen is very difficult to get into trouble. You really have to try to get into trouble. So you'll be fine. Don't worry. DS print definition of prior experience after company got acquired. So basically filed a labor cert, it was denied after an audit. The employer is willing to restart the process, but in April 2013 employer has been acquired. Can I use the experience gained with the prior employer? But that depends. The normal rule is if the tax ID number of two employers is different, you can definitely use the experience gained with the prior employer with the next employer. However, if you are claiming that this is a successor in interest, you may not be able to. That becomes a little iffy. Even there, at least the Department of Labor regulations don't stop you from using that experience, but I would be a little bit more careful. Okay, so it depends upon the kind of takeover that occurred. Next question is MTR 1975 AC21 related question. I'm currently on EAD AP, thinking of moving to same similar job to another employer using AC21. Haven't found a job yet. There's an awkward situation. I need to tell my current employer you need to give them a 3-month notice. That way you collect a significant bonus. But however, if the current employer revokes my I-140 and AC21 filing is done 3 months later after I have a new employment offer, will that be a problem? And the answer is probably not, because technically, if the employer revokes your I-140 while you are still working for them, you are on EAD, right? Yes, you are on EAD. If USCIS for some reason does not realize that you are entitled to your AC21, they are required to send you a notice of intent to revoke your 485 and give you 30 days to provide AC21 justification. At that point, you can send them a letter saying, here is my job, I'm starting this job 2.5 months from now or 2 months from now, because I had to give a 3 months notice to this employer, and this future job is same or similar. That should be fine. But you should tell your employer, if possible, not to revoke your I-140 till your last day is done. That's the better way to do this. Is it common practice to hire an attorney for AC21? Please do. Do not try to do it yourself. A lot of people do it. A lot of them go through. But this is a one-shot deal. You mess up in this, it's very difficult to correct it. Get yourself a lawyer. Don't do it yourself. Dorothy wants to know, my I-485 is denied because my husband's I-130 was denied. So the user handle is ADAZE2012. Can I have two attorneys filing G28? No. No, you cannot have two attorneys G28 in the same file. But if you are concerned about, and your concern is you want a better representation, you can always get a second opinion or a review. Okay, one can be representing you and the second one can be reviewing. That would be an easy way to do it. Priya C says concurrent filing for green card for widowed mother. I'm a US citizen thinking of having her stay with us long term. She's here. She came in July 2013 on a visitor visa. She's been coming regularly for the last 10 years. Question number 1, do you have any advice on what we should take care of when filing concurrently? The most important thing is that she should not have had a preconceived intention when she arrived in July to file green card. Later on, a few months later, if her intention changed because you persuaded her, we should be okay. What forms do I need to fill? I-130, I-485, I-864, medicals, biometric information, advanced parole. Yeah, that looks about right, Priyanka. I can't think of what else would go there. Just read the instructions on the I-130 and 485. Whatever the supporting documentation is supposed to go with it, make sure it is attached. P. Hariharan 650 EB2 eligibility. Graduated in July 2005 with a bachelor's degree, 12 plus 4. Worked in India for 4 years and 7 months. Moved to USA on an L1B visa. Same employer, 3 years and 9 months experience. Can I file under EB2? Will DOL consider my US experience? And the answer is experience with the same employer can only be considered if the green card job is more than 50% different than what you have been doing with this employer the last 3 years. Okay, so or 3 years 9 months. Let's say you came in as a software engineer and now they are giving you the title of project manager, and the project manager has a lot more leadership role than actual technical work, such that the job is more than 50% different. You can use the experience, then you can do the EB2. Okay, I think the same message was posted twice. The last question posted, sorry guys, I think Monica did not open this thread in time. Normally we open the thread for posting questions pretty much a couple of weeks ahead of time. This time we did only a couple of days ahead of time. So you were not able to post all your questions, but whoever is on the phone, I will answer their questions after this. Monica posted a question regarding educational equivalency. Do master's degrees, whether from renowned accredited college universities like IIM or IGNOU through distance program, is not considered at par with masters? Every foreign degree has to be evaluated according to EDGE database. EDGE database maintained by American Association of Collegiate Registrars and Admissions Officers, AACRAO, ACRAO EDGE. So EDGE database has to be consulted. If the degree is equivalent to a US master's degree, you have a fairly good chance of going through without any problem. Okay, I'm going to open the floor to follow-up questions only. So people who have follow-up questions, please press, let me try to remember, I always forget this. Is it star 5 or 5 star? Press star 5 on your phone. Okay, one person. All right, there is only one follow-up question today. 2 follow-up questions. No new questions, just follow-up. Okay. In the order that you logged in, go ahead, sir. Irvine, California, go ahead, please. California, area code 949. Okay, there's a lot of disturbance on your phone. You may want to call back in and then press 5 star. Let me try one more time. California, go ahead, I can hear you. Okay. California?
Yeah, I'm actually on the road.
Yeah.
I'm on the road, so if it's too noisy, let me know.
No, yeah, go ahead.
Yeah, I'm the one who posted the question about, I posted the question about prior experience after the company got acquired.
Okay.
Yeah, I'm just hoping you can elaborate a little bit more on the type of the acquisition. That actually allows that type of using the prior experience.
Okay, here is the easy way to find that out. Your company would definitely have some immigration lawyers who work with them. Ask them if the company is considered to be successor in interest. Ask them also. Let me put you on mute. I'll open you up because there's a lot of disturbance on your call. I'll open you up once I finish this answer. So ask your company's immigration lawyers if the acquisition was in the nature of successor in interest. If it is not, there is absolutely no problem in using this experience. But again, let them double check. There are one or two little complications that could crop up. Second thing, if it is a successor in interest, then let them assess the risk. Let them read the Department of Labor regulations and see if the experience can be used anyway because it's a different tax ID number. But if the ID tax ID remains the same, then you cannot use the experience, okay? Go ahead if you have any other questions.
Sure, yeah, that sounds good. Thank you.
Good luck, sir. Okay, I'm sorry, I don't know what area code you're calling from, probably voice over IP. Go ahead, I can hear you.
Mr. Khanna, this is Priyanka. Can you hear me?
Haan ji, Priyanka ji, I can hear you.
Mr. Khanna, I posted the question about concurrent filing for green card for widowed mother. I just have two quick follow-up questions, please.
Yes, ma'am.
First one, in general, do people hire lawyers for filing for parents in case of concurrent filing? We were thinking of doing it ourselves, but we are open to suggestions.
Well, that's a difficult question. These days, they are creating a lot of problems for people who don't have birth certificates for parents, marriage certificates for parents, or birth certificates for the petitioner, which is you. So if you have these documents, there is, in my view, there is no need for a lawyer. But certainly if you have the freedom to hire a lawyer and don't mind spending the money, you would be better off just getting a lawyer and let them take care of all this for you.
In case of my mother, since widow, would a marriage certificate be applicable?
I think what you will need is both a marriage certificate, if not a marriage certificate, affidavits from two people who attended the marriage, and your birth certificate, as well as the certificate of demise of your father, the death certificate.
Okay. And the other question I had, Mr. Khanna, is you mentioned that she should not have had any preconceived intention when she first arrived in July. So how do we demonstrate that?
Well, normally, if you are applying a few months after she entered, and it is quite clear that you started collecting the documentation, for example, affidavits, etc., a few months down the line, I think because intention is a matter of circumstantial evidence. Circumstantial evidence, because it's in your head. Nobody can see what is inside your head except based upon the behavior and the general circumstances around what you do. So therefore, intention can only be proven indirectly. And things like when did you start collecting documents, when did you start filling out the forms, all these things could count towards that.
Okay.
Okay.
Okay. Thank you very much.
Yes, ma'am. And you can call me Rajiv. Everybody, please call me Rajiv. Also,
Okay.
most of these,
Thank you, Rajiv.
certainly, most of these cases, problem occurs when people apply too quickly. So like within 30, 40 days, 50 days after parent lands, they apply for a green card. USCIS can cause issues.
Achha. And in general, how many days later do most people should apply? What do you recommend?
There is a 30, 60-day rule. I'm not sure how much of a rule that really is. Government can question any time, but never apply within 30 days, avoid within 60 days. After 60 days, it should be okay, but try to delay as much as possible.
Achha. Thank you very much.
You're welcome, ma'am. Good luck.
Thank you.
Bye.
Bye.
Okay, one more hand came up. Ohio, area code 513. Go ahead, please.
Hi, Rajiv. I'm the U.S. citizen filing for wife, green card for the wife on L1A.
Oh, yes.
A couple of quick questions.
Sure.
We are concerned a little about a couple of minor things. One, I am out of a job for the past few years. So we are totally filing on her sponsorship, like she is sponsoring for herself financially, the 864. So that one. And two, we got married here in a court marriage in Indiana. We don't have any photos or anything about that on that marriage. So a couple of these things we are concerned.
The issue of sponsorship is tricky. We have to talk about numbers, etc. You can always get a joint sponsor or a co-sponsor, whether it's a friend or a member of the family. If there is an issue, they can join in to sponsor her. Okay. And as far as the first issue was the sponsorship, what was the second issue? It's slipped my mind.
The photographs on the marriage.
As long as the marriage is genuine, for example, if you have known each other for a few years, you've been dating, and you can prove some of that, I don't think that's a problem. You're living together, right?
Yeah, absolutely. We are living together. We have many photographs of the after that, and we can produce affidavits from people. All that stuff is there.
I think you should be okay.
We have presented a joint account. We have presented the lease that we have where we are living together, and we have a credit card that's together for a couple of years now. All the stuff is there.
As long as the marriage is genuine, as it obviously appears to be, you should not have a problem.
Okay, great.
All right.
And on the EAD thing, when exactly is the EAD issued here? Is there too much of a difference between when the green card is, you get the green card and when you actually get the EAD? One thing, and two.
It should be issued within 90 days of when they receive the application, whether it is applied with the application or after.
For the EAD, you mean?
Yes. So if you apply it with the 485 or after, it should still be 90 days as far as I know.
Is there too much of a difference between getting the GC and the EAD usually?
There can be. I mean, EAD, they shoot for 90 days. Green card can go 6, 8, 10 months, 2 years even, but not usually. Usually it should be wrapped up within a year.
Right. Okay. And like I said, she's on an L1A, and it's expiring soon, so we are kind of doing it in the last moment. If she doesn't get the EAD in time before that, and her L1A doesn't go through before that, what happens? Can she continue to work?
Did you log in late? Because I already answered that question. She cannot work, but she can continue to stay in the United States.
Right. Yeah, that's what I thought. Okay.
Okay, but she can work once the EAD comes, then she can do whatever she wants, work for any employer, start her own business, whatever she wants.
If her L1 extension is filed, she can continue to work based on that, of course.
If it is timely filed, she can continue to work up to 240 days, yes.
Okay, fantastic.
Okay.
All right, great. Thank you so much, Rajiv.
You're welcome. Good luck.
Appreciate all your help.
My pleasure.
Appreciate your time. Thank you.
My pleasure.
Thanks.
California, did you have another question? California, area code 949 on the road.
Yes, yes, I'm here. So I actually have additional follow-up question. So my labor certification has been denied after like audit and after everything after 1 year, and I only have 1 more year left on my original 6 years of H1. And my question is that I actually work for an employer that does not do like H1 or green card as a policy. So I'm actually an exception in the company that they really could not fill the position. So they're actually doing a H1B, but unfortunately the HR did not do the paperwork during the recruitment process properly, and the labor got denied. So I was just wondering if my case is like well qualified for any sympathy basis, so I can approach a local senator or not do anything on that line.
There is no such thing.
Okay.
Okay.
Okay. Is there anything at all in general that you would suggest I do, or?
I could have considered having you file an appeal against the denial of the labor certification. When was that denied?
Just 2 weeks ago, in end of September.
Well, why don't you talk with your lawyers and maybe get an appeal filed? Appeal will stay pending for 3.5 years. While the appeal is pending, you can continue to get H1 extensions. But there's only one problem. You have to be careful with this appeal, because if it is the same employer successor in interest, then they cannot file a second case without withdrawing the appeal. And you can time it so that you have enough time on your H1, withdraw the appeal, get the H1 extension, withdraw the appeal, and then file the new PERM application. So it can all be timed. But filing an appeal, you've got a limited amount of time. I think it's 28 days. You've got to get it filed.
Okay. And how long does an appeal typically take based on the current processing time?
3.5 years.
I see. Okay.
Okay.
All right. That answers my question. Thank you.
Good luck, sir. Okay, guys, anyone has any question of any kind, go ahead and press *5. One question from New York. Press *5 on your phones. Okay, we have only one more question. New York, go ahead, please.
Hi, Mr. Rajiv Khanna. This is Kalpesh from New York. I had set up a call with you 3 weeks ago about my mom's green card and filing for her probable citizenship.
Okay.
And we went through the questions over that call. So I was reading more on it, and what I encountered that she has one of her stay, which is more than 6 months, and to prove that she maintained her residency here, we have to give some documentary proof. Now, she doesn't have any income, and till now we didn't file for any tax returns.
Okay, hang on
So
one second, one second, Kalpesh ji. Let me try to understand.
Yeah.
The question relates to maintaining your green card, your mother's green card.
And also maintaining, and then not to maintaining, whether she has a continuity of residency.
That's
Her intention was-
for naturalization purposes.
Yeah.
Okay. Does she have 2.5 years of physical presence?
She has it. She
And-
will eventually have it.
Okay, and
but
then
in between there, she. Mhm.
there is one period in which she was outside USA for more than 6 months.
Yeah.
How many months was she outside?
7 months. 7
Okay.
months, 1 or 2 days.
And you have a good explanation for it?
Well, is an explanation requires only verbal in nature, or another proof that she was here in terms of paying her and filing her income tax?
No, that's not the most important thing. If you're not making any money, how can you file an income tax return? Okay, I don't see that as a necessity. I don't think so. But
Okay.
what is more important is, look, my permanent home is the United States. My children live here. This is where I live. This is my room. This is where I sleep. This is where I work. Or if not working, this is where I stay. But I had to go to India because we have some property that needed to be disposed of. I got there in the month of August. I got myself a realtor. We listed it for 3 months. We interviewed 17 people. Then we had to relist the property again in December. So, basically a detailed explanation of why she was gone for 7 months.
Mm.
Okay? They don't always have to ask it, but they can ask for it. And they ask for it in writing.
Okay.
It comes in the form of a request for evidence.
Request. So that is not part of filing. It comes later on if they want.
It comes
question
exactly.
it. Okay. And okay, so in a whole 5 year, I think.
Yeah,
so
I
spoke,
want to step back here for a second. I may have misspoken. I'm come to think of it, I don't remember whether the N470 requires that you attach an explanation while filing, or whether they just ask you to list the times of absence and then later on send you an RFE. I don't remember off the top of my head, but it's always in writing.
It's always in the writing. So most probably it will be after the fact they would be asked.
I think so, but I don't remember. See, remember one thing, Kalpeshji, I have not filled the form in decades. So I don't remember what the...
Okay, that's fine.
Yeah, I look at the forms when there is a necessity. I review what is being filed, but I don't... So I'm not that familiar with all the entries in the forms.
But in terms of explanation, we can have that as an explanation. And then we don't, because I was thinking whether should I go and ask the accountant to do amendment of the previous tax year and go about filing even with the zero income.
I see, if somebody has not made any money, how can they be filing tax returns? As far as I know, the only requirement is that you should not have filed a tax return as a non-resident. It is not that you must have always filed a tax return. It is that you must not have filed a tax return as a non-resident. So if you are filing, file it as a resident. I think that's what the requirement is.
Then okay.
Okay.
And the other question is like, if my younger sister, she became widow, so now if she at all has to file for her, it becomes as unmarried children, or?
It is unmarried, yes. If widowed is unmarried.
Oh. Okay.
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 Good luck, sir.
Thank you.
You're welcome.
Yeah.
Bye-bye. Okay, folks, last call. Anybody has any other questions, press *5. Any questions at all? Okay, very good. Looks like we are done. Great to see you. I'll see you again in 2 weeks. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.